When you're a public official, you probably deal with different issues in a lot of different places. Meetings, boardrooms, talking with citizens for and against different issues. Dealing with public employees, zoning and land use issues. But this is one place you don't want to be. In a courtroom, being sued. Defending your actions as a public official in a liability lawsuit. All too often, public officials are being sued for mistakes that end up in here, in front of a judge, trying to defend their actions and losing. Losing big. Losing their position and thousands, sometimes millions of dollars. Now, even if your governmental entity can afford such costs, public officials may be held personally liable or responsible for public acts and for punitive, or in other words, punishing damages. Insurance may not cover punitive damages. These costs could be coming out of your pocket. And if it can be proven that a public official knowingly did something wrong or acted outside of their official responsibilities, then that public official could be liable to pay all costs. Costs like compensatory damages, interest, lost profits, and attorney's fees. Avoiding such costly mistakes, learning how public officials can control these types of liabilities is what we're going to be covering today. Many officials believe that they're exempt from lawsuits because they have sovereign immunity. Well, this just isn't so anymore. Increasingly, the legal protections of sovereign immunity for public officials have become more and more limited. The courts have decided that local public officials are liable and can be sued for wrongful acts, wrongful omissions, and for violating federal laws. Now, let me repeat that. Over the years, the courts have repeatedly decided that local public officials can be legally liable and can be sued. Now, there are three categories that public officials are most often hit with a lawsuit. The first area is employment practices. The courts have often ruled that public officials violate public employees' federal, civil, and/or constitutional rights in hiring, disciplining, preventing harassment, and terminating employees. The second area of liability that public officials are often sued for is in zoning and land use cases. Public officials often lose these cases because they ignored their own land use laws or they violated a property owner's civil and constitutional rights. The third area involves conducting public meetings. Here, officials have been sued over failure to properly publicize, schedule, conduct, or document meetings for the public. Now, let's start off by talking about the number one cause of public official liability cases: employment practices. Why are over 80% of the liability cases concerned with employment practices? Probably because there are so many laws that could be violated. For example, public officials not only have to follow their entity's charter, incorporating documents and employment policies, but any state laws too, including workers' compensation. After local and state laws, there are federal laws concerning employment practices, including the Civil Rights Act of 1964, the Fair Labor and Standards Act, the Americans with Disabilities Act, the Occupational Safety and Health Act, the Family Medical Leave Act, the Equal Employment Opportunity Commission rules, the Age Discrimination in Employment Act. And within these federal employment regulations are what are known as protected classes. People are protected in the workplace against discrimination in hiring, discipline, and discharge because of race, color, religion, sex, including pregnancy-related conditions, national origin, age, physical or mental disabilities, associating with a protected class. Retaliation against employees for whistleblowing, filing complaints, and testifying about unlawful conditions or violations may also be illegal. Now, if it seems like a lot, you're right. But let's take a step back and see how to minimize your liability in employment practices. First, you need to plan ahead to control potential liabilities before they happen. Unlike car accidents and personal injuries, which happen suddenly and uncontrollably, employment liabilities take a while to develop. You generally have time to plan and deal with them before they become a lawsuit. You have to stop, look, and listen. Stop, look, and listen for what I call the D's of employment liability lawsuits. drastic action, documentation, discrimination, discipline, and discharge. Now, anytime you hear these words, be careful. One of the biggest problems with some public officials is that once in office, they want to take drastic action in employment matters. They want to quickly discipline or discharge employees. What they're actually doing is quickly setting themselves up for a potential lawsuit. Be careful about quickly taking drastic action in employment practices. Stop, look, and listen first. Stop and evaluate your plans and look at the situation first. Contact and listen to your attorney or solicitor and your human resource advisor before doing something drastic. Before making any decision, everyone should be looking at one of the other D's of controlling employment claims: documentation. The first document you have to check is your governmental entity's charter of incorporating documents and your state statutes. These should specify what authority and responsibilities you as a public official do or don't have. If these documents don't support your actions, then you could be liable in a lawsuit. The next document you need to check is your employee handbook and policy manual. This is your blueprint for avoiding employment claims. Providing employees with handbooks and manuals is an easy way to summarize employment policies and procedures for managers, supervisors, and employees. They also need to conform to state and federal law. That's because this is probably the first thing lawyers and judges are going to look at in a liability case. But there are a few things to keep in mind with these documents. They should clearly state that they do not constitute an employment contract. They should also state that you can modify or make changes to them at any time. Employee handbooks and policy manuals also need to be continually reviewed for accuracy and consistency. You should also document that everyone understands and is following these procedures. Now, even though your organization may have at-will employment standards, you still have to be careful. At-will employment, where workers aren't obligated to keep working and employers can discharge them at any time, doesn't mean you can fire somebody whenever you want. People have done this and have ended up being sued for one of the other D's of employment lawsuits: discrimination. The 7 most common employment liability lawsuits that public officials have to defend themselves against are wrongfully firing someone, ignoring or encouraging workplace sexual harassment or discrimination, discriminating against people with mental or physical disabilities, violating wage and hourly standards, perceived discrimination or reprisals against whistleblowers, discrimination against or denial of civil rights. As you can see, a lot of them involve some form of discrimination. And charges like these result from when you try to discipline or discharge an employee. Again, be careful. Stop, look, and listen when you start hearing the D's of employment lawsuits. By using good documentation, you can control and minimize such lawsuits. First of all, your procedures for dealing with disciplinary and discriminatory actions must be clearly documented in employee handbooks and policy manuals. Now, you need to take any discrimination complaints and disciplinary matters seriously and deal with them quickly. Don't blame them on some disgruntled employee or let them languish on somebody's desk. Meeting with an employee for work-related reasons should be documented. This includes discussion on policy procedures, disciplinary actions, grievances, or discriminatory complaints. And it's just safer to assume that what you're documenting will be reviewed in court. So you need to be careful about how you write your documentation. The writing should be in a neutral style, like a newspaper article. It should document who, what, when, where, why, and how, not someone's opinion. The writing should also be specific. If someone says something discriminatory or harassing, write exactly what they said, not that it was racist or rude.